we're all present. So I'll hear argument from the state and the defense and any final word from the state. There is no mitigation, is that right? No witnesses?
Yes, sir, that's correct.
State?
I'm stating we reserve closed.
All right.
Good morning, Your Honor. May it please the court. Before I say anything on behalf of Colin Gray, I want to acknowledge what everyone in this room knows to be true, that nothing that happens here today, no argument that I make, no sentence this court imposes can restore what was taken on September 4th from these families and from this community. Colin Gray does not come before this court to be excused for that. He comes to be sentenced for what he did and not for what his son did. When the jury convicted Colin Gray in March, it never heard from the one person who knew the whole truth of what was planned in that house. Colin Gray did not testify at his father's trial, and this court has now spent a week hearing that missing evidence. And 2 days ago, it made findings about that missing evidence. So I want to begin not with our theory, but with this court's own record. 6 things now stand in it that no jury ever weighed. First would be the concealment, from the only voice with first-hand knowledge. Colin Gray told his court that he actively hid the depth of his involvement in that online community from almost everyone in his life, including his father, that his father did not know what he was planning. We did not ask the court to take a confessed killer at his word. We asked the court to notice that his words matched the physical evidence that the jury did see. The hidden notes, the burner accounts, the absence, after 2 years of investigation by the state, of a single text, email, or single witness placing that plan within Colin Gray's knowledge. Second, the notes on Colin Gray's phone show hostility towards his father and expressed hope that his father would be punished. I'm not going to read those words in the courtroom. I know the court saw them during the trial. I raised them for only one reason. A son who wanted his father punished and wrote it down had every incentive in the world to implicate him, instead confirmed that he kept that world a secret from Colin. Third, the timeline moved because Colin Gray was in fact moving. The court heard that Colt accelerated his plan when his father sought mental help for him through the school. The original plan called for this execution to be on the anniversary in February of the Parkland shooting. Because Colin was taking steps, Colt decided to counter-move and accelerate his plan. Was it enough what Colin did? Obviously not. The jury has said so, and Colin accepts that. But it was not nothing, and it was not indifference.
Hi, good morning. My name is Charlie. So I'm calling from the State Resource Center.
Please turn your phones off.
Fourth, the defense expert who testified before the court this week described the family profile of children who fall into these communities, the true crime community. Parents who are absent, parents who do not nurture, parents who physically abuse. Your Honor heard 9 days of trial evidence about Colin Gray, and whatever else it showed a father who was present, who pulled his son towards hunting in the outdoors, who was trying, however ineptly, to get him back into school and away from his computer, who didn't physically or mentally abuse him. And the same expert told this court the single best intervention for a child is to get him away from that community, to get him off of the computer. That's the intervention that this untrained father was groping towards, without even knowing the community's true nature, without even knowing his son's involvement in that community. Fifth, the state's own evidence found that the one adult who was inside that hidden world with Colin Gray was not Colin. The director of the Division of Family and Children's Services testified in this courtroom that the boy's mother was, in the director's words, fueling this ongoing obsession with school shooters. The jail calls the state played showed her relaying the community's praise into her son's cell until the court ordered the contact stopped. That is not my characterization. That is the state's witness, the state's exhibit in this courtroom this week. And sixth, on Tuesday, this court found the motive. Not bullying, not hatred, in the court's own words, for the infamy of it. Infamy, Your Honor, is the currency of exactly one place, the true tribe community, the hidden community that Colin Gray served in secret. The motive this court found did not live in Colin Gray's house. It lived in a world that Colin Gray did not know existed. Now, Your Honor, the state's strongest foreseeability evidence at trial was one simple fact. Marcy Gray had told Colin to lock up the guns. I want to spend a few minutes on what this court has learned since then about the warning and about Marcy Gray, because the companion record has shown what stood behind it and how much of it never reached the man who received it. Marcy knew the extent of her son's immersion in that community because she was inside of it with him. She knew he idolized school shooters. She knew he was corresponding with the convicted school shooter in Florida. By the evidence now before this court, that fascination was the thing the two of them shared, and none of it was shared with Colin Gray. So consider the difference between two sentences, two articulations. Lock up the guns from an estranged co-parent in one sentence versus lock up the guns because our son idolizes school shooters. He writes to one in prison, and I've been inside that world with him. That is a different sentence entirely, a different statement entirely. Colin Gray only heard the first sentence. He was never told the second. And foreseeability, as a measure of what a man morally deserves, has to be judged by the warning that he actually received, not the warning that she was in a position to give. Why would she keep such a secret? The record before this court suggests an answer. Through her own actions, the addiction, the conviction, the loss of her children, Marcy Gray had forfeited the ordinary place of a parent in her children's lives. What remained to her with this son, with Colt, was one thing: this fascination they shared. It sat in their relationship where ball games and fishing trips sit in other families. It was the thing they talked about. It was theirs. And to tell Colin about it would end it. We know what that relationship meant to her because the state showed us. After September 4th, after 4 people died, she still could not let it go, and she still discussed it with her son from his cell until a court finally stepped in and made her stop. I don't say this to condemn her. She has lost a son to this too. I say it because it makes her silence comprehensible. And whatever her reasons, the fact stands, and it is the fact that matters today. The knowledge was hers. It was never his. Now weigh that unexplained Marcy from the way Colin had to weigh it against the other voices in his ear. In May of 2023, a Jackson deputy sheriff stood at Colin Gray's home, investigating an online threat given to him by the FBI, traced to that address. Colin did not stonewall that officer. He volunteered, unprompted, on video, that if there was evidence his son had made the threat, the guns would leave the house immediately. He never got that answer. The case was closed. 15 months later, trained counselors spent hours with Colt, and what came home to Colin was a consent form for a counseling program to get services started through the school, which he filled out and returned. The vocabulary was anxiety. That is the information that this man was holding. One voice saying lock up the guns with no reasons attached from the one person whose history with him made her the hardest voice for Colin to credit. A co-parent convicted of a crime against him, ordered to stay out of this county, whose children were removed from her by the state, and who was, by the record of both of these proceedings, the parent who physically abused Cole, who had threatened to kill Cole. Colin had to choose between listening to that voice or listening to the voice of the credentialed voices, and that's what he chose to do. This is not a heart indifferent to human life. This is how every rational person orders information, and it really is one of the many tragedies of this case. Because here's the cruelest part. Colin Gray had already told the deputy sheriff out loud at his home the exact condition on which he would act. Tell me to this and the guns are gone. Marcy Gray held that evidence. The idolization, the immersion, the correspondence with the convicted shooter. Had she given him the knowledge that she had, she would have handed him the very confirmation that he publicly committed to act upon. But she never did. The confirmation that he was waiting for existed, it simply never reached him. And September 4th itself proved which parent had that knowledge, because Marcy is the one who immediately called when she received the text, knowing what was going to happen, not Colin. I want to be careful because I know that others had information as well, others in Cole's family. And I don't believe they held anything from Colin out of ill will. I just don't think they perceived the significance of the information that they held. But that's precisely the point. That the people closest to this boy, holding the most alarming pieces of this picture, did not foresee what was coming. They could not foresee it with more knowledge, and the moral weight of failing to foresee it cannot justly be concentrated, undivided, in the sentence of the one man from whom the picture was kept. The verdict aggregated this household's knowledge. The sentence should match the knowledge of one man. So what did Colin Gray actually know? Because that, not what was kept from him, what he actually knew is what the jury convicted him on. And it is what the court must sentence him upon today. He knew his son struggled, anxiety, stress, trouble fitting in, trouble making friends. He knew the boy loved guns, as Colin did, as Colin's father did. He knew he had a temper. What he knew was that Cole was a struggling adolescent, one of the great many in this country. But not one single fact from the hidden world of the true crime community where the plan actually lived, was tended, and grew was known by Colin. And the incidents the state lined up at trial did not arrive in Colin Gray's life as a single timeline. They arrived scattered across months, each one surrounded by stretches of a child who laughed, who was bright, who loved his computer, and video games, who played guitar, who went into the woods with his father. A prosecution exhibit can compress 292 days into a column of red flags and delete every ordinary day in between. A parent lives all 292 of those days. Hindsight isolates the spikes. A life lived besides the child averages them. The jury found that the average this father struck was criminal negligence, and he accepts that. But there is a difference in sentencing between a man who watched a fire build and did nothing and a man who saw sparks amid seasons of calm and misjudged it. And how hard was Cole to read? The state answered itself that question in the court this week. The state court told the court that when this boy said the words, "I hear voices, I want to black out," that he was not breaking down. He was performing a scripted imitation of his idol Nicholas Cruz's arrest interview. An Easter egg planted by a boy the state describes calculating up to the second of the shooting. I accept the state's proof that this court will remember that among the greatest warnings charged against Colin Gray at his trial was that his son spoke of hearing voices in the days before the shooting. If that talk was theater, a callback that only a student of school shooters could even recognize, then the most alarming thing that this father ever heard from his son was a line from a script he had no way to know existed. The same record cannot call it performance in one sentencing and an unmistakable warning in the other. And the state also said that it does not know why this boy is what he is. I don't know why the shark is the way the shark is. Maybe he's born that way. Maybe something no one can name. Your Honor, that was an honest answer, and I respect that answer, and I respect the state for giving it. But it does have a consequence for today. In the state of Georgia, with the complete record, every expert, every jail call, 2 years of hindsight, if they cannot explain this boy, then the law cannot justly sentence an untrained father as though he should have understood him in real time across the living room. Foresight cannot be demanded where hindsight has failed. The FBI sent a warning, sent a tip to Jackson County Sheriff. They investigated and closed the file. A deputy sat with him and left. Trained counselors spent time with Colt before the shooting and sent him back to class. Nobody trained to see this side. No parent is trained to look at his own child and see a mass shooter, especially when the professionals who are trained to do so did not. On Tuesday, this court wrote the first entry in the ledger that history is going to read as a pair. The killer, the one who planned it, who hid it, who staged it, and who carried it out, received a sentence of life without the possibility of parole. Made all the more exceptional by the age of the person at the time the crime was committed, 14 years old, the maximum that the law allows. Today, this court writes the second entry. A father convicted of negligence, of failing to perceive what his son, by his own account in this courtroom, deliberately hid from him. These two entries have to be morally legible when they are read together. The entire architect of our homicide law, the reason we grade these offenses at all, is the line between the harm a person intends to do and the harm a person fails to prevent. Colin Gray is 55 years old. A sentence of 30 years, 40 years, 80 years. Negligence counts stacked one upon the other is a death in prison sentence. Functionally, it's the very sentence this court just reserved for the individual, the killer himself. If the father's sentence looks like the son, then that line is gone. And this court, in the first case of its kind in Georgia, would have written the precedent that erases that line. There's exactly one comparable case in American history, and I'm sure the court is aware of it. The parents of the Oxford High School shooter, convicted of involuntary manslaughter for 4 deaths, were each sentenced to 10 to 15 years with their counsel run concurrently. And Your Honor, their warnings were sharper and closer than anything in this record. They bought the gun 4 days before the shooting. They were called into the school the very morning of the attack, asked to take their son home, and declined to do so. They were shown their son's drawing of a gun and the words, quote unquote, "the thoughts won't stop, help me." And they said nothing to the school about the weapon that they had recently purchased their son, and they left him in that school. 10 to 15 years concurrent was the considered judgment of that court after victim impact testimony that was every bit as devastating as what the court has heard in the past week and today. We would ask this court not to make Georgia the national outlier in this first case of its kind against a defendant whose warnings came with less and whose efforts were more. Briefly, Your Honor, as to merger, we have filed a brief. We are asking, as a case of first impression in Georgia, we believe that all of the counts should merge into count one, based upon the fact that Colin failed to do one thing. Now, I understand, without waiving any objection, the court may disagree with that argument. And as I said, I would understand because this is a sentence of first impression and an issue of first impression. Every count in this indictment arises when one continuous course of conduct, one gun, one child, one failure of perception over a span of months. The 18 cruelty counts do not describe 18 separate decisions by Colin Gray. They count the children present when the son acted. The number of those children is a proper measure of the gravity of this harm, and the court should weigh it in fully fixing the term. But to stack negligence counts consecutively is to count that gravity twice. We would ask the court, if it disagrees with our argument on merger, to run all the counts concurrent. Colin Gray did not choose his circumstances. It arrived by a telephone call from the Division of Family and Children's Services telling him to come get his 2 youngest children because their mother had relapsed. Throughout he and Marcy's marriage, it seemed her sole contribution to this family was to insert chaos. Immediately and without condition, when he received that call, he drove down and picked up his 2 youngest children and brought them back to monitor. Was he overwhelmed? Was he underprepared? Yes. Did he have a support system? No. Will Will the state argue that had he cooperated more with the school with defects, that he could have had a support system? I'm sure they will, and we do not contest that. That, too, is part of the failure that the jury found and for which he will have to answer. But an overwhelmed father's imperfect engagement with bureaucracies is negligence. It is not indifference. This is a father who was trying. This was a father who was constantly in touch with his children. Your Honor saw the text messages that were admitted to evidence at school. Colin Gray was positive. He told his son that he loved him, that he was proud of him. He encouraged him to go to school. He told him how happy he was when Colt told him that he had a good day at school. This was not an absent father. This was not a distant father. This was not a harsh parent. And the rifle, the court should understand what the rifle was meant to be, because it belongs to a larger and sadder inventory. Colin's plan for his son was the only plan that he had ever seen work. His relationship with his own father was a troubled one, and it was redeemed to the extent it could be in the woods, hunting, side by side with his dad. Your Honor has a letter from his sister that details that a little more clearly. So when Colin's own son began to slip away from him, Colin reached for everything he could think of and everything that he could afford. He bought his son gifts, guitars, computers, gear. He tried, however ineptly, to get him back into school. He filled out the constant counseling paperwork. He took him to the range. He took him hunting. And the hunting rifle, because hunting was the language in which a great father had once managed to say to a great son what he could not say in any other way. He believed that his presence and his generosity in the outdoors could pull Colt out of troubled waters. What he did not comprehend was the current that ran through a world. And one more thing about Colin. From the first hours of September 4th, as the court saw, he cooperated. He sat with investigators that same day. No lawyers, no conditions, and he told the truth. In fact, the state built his case on his own candor. He has no prior felony record. He's been in custody 22 months now. There is no world in which Colin Gray will reoffend. Specific deterrence and incapacitation are simply not a part of this case. And his punishment did not begin with the verdict, and it will not end with his release. His son is in prison for life. His daughter is in foster care. His youngest son is in foster care. His family is gone. His name will forever be associated with this tragedy for the rest of his life and afterwards. The state may tell the court this case demands a message. Your Honor, that message has been sent. On March 3rd, a unanimous jury delivered the first conviction of its kind in the history of Georgia, and it was reported throughout the state and throughout this country. Every gun-owning parent in Georgia already knows that the law changed that day. Deterrence requires credible condemnation. It does not require that a 55-year-old first offender die in prison for negligence. A decade or more behind bars, following the first conviction of its kind, is a thunderous message by any account. So here's what we are asking of the court. On each count of murder in the second degree, we're asking the court to sentence Mr. Gray to 20 years, to serve 10 years in confinement, with the balance to be probated. On the counts that survive merger, 10 years concurrent. On the reckless conduct counts, 12 months concurrent. All the counts concurrent with each other. An effective sentence of 20 years to serve 10 years in custody. That is not leniency. 10 years in a Georgia prison for a man who never intended to harm a single human being is among the most severe sentences ever imposed on a parent in American history for the act of a child. It honors the statutory minimum. It accounts for every life lost and every child in danger. It stands beside the crumbly sentences rather than dwarfing them. And it preserves the one distinction this week of sentencing will be remembered for: the difference between the boy who carried that rifle and pulled the trigger and the father who did not see it coming. Your Honor, we understand the gravity of this situation. 4 people are gone, and nothing the court can do today can change that. But the question today is narrower, and in some ways harder. What does justice require when a father's negligence and a son's concealed intent meet on a single morning? This court has heard from the son himself and how completely that intent was hidden from the father. It has found that this was done for the infamy of it, the currency of a world the father never knew existed. It is already imposed on the one who did the killing the heaviest sentence the law allows. The sentence can be severe and still be just. We ask the court to impose one that is both the sentence we've asked for and to leave standing the line the law has always drawn between negligence and murder. Thank you.
Thank you, Mr. Hobbs. Mr. Smith.
Your Honor, the defendant is confusing and conflating the evidence that was presented last week in the trial of Colt Gray. As disgusting as Marcy Gray's involvement in the TCC was shown in court, the very first phone call on October 1st, 2024, a month after the shooting, Colt Gray is heard directing her of how to access this TCC true crime community. He brings her into it after the fact. They're conflating the time periods of when that happened. And they're also conflating his knowledge of her knowledge. The phone calls that the state showed in his trial, where Marcy Gray is continuously searching for the Ethan Crumley parents, why were they charged, and the sentencing for that, and that simultaneously with those Google searches that she's making, her and the defendant were making phone calls 6 in 1 hour simultaneously with her doing that. Showed to this jury that they were in communication with each other about the threat Colt Gray posed, their son posed to a school shooter. They're conflating the timelines of when these things happen. So let's look at the actual timeline in this case. In 2021, law enforcement came to his house because his son had searched how to kill your dad on the school computer. 2 years later, in 2023, law enforcement again came to his house because his son had threatened to commit a mass shooting at an elementary school. And at that meeting, law enforcement asked him to restrict his son's access to guns. But instead of doing that, just a few months later, for Christmas, he bought his son a 6-Sauer M400 rifle. And that summer, as his son's emotional health spiraled, this defendant allowed him to keep that rifle in his room. He was convicted for what he did know. And Colt lying, whether or not Colt was lying when he says he heard voices, he said to his dad he heard voices. And that should be the red flag that every parent should act on, especially one who has already been warned that his son wants to commit a mass shooting at a school. The defendant was convicted of ignoring a substantial and unjustifiable risk. And in order to settle upon an appropriate sentence, the court needs to look at the nature of the risk he ignored. This is that risk. This was the risk that was staring him in the face every day. It culminated on August 6th, almost a full month before the shooting. This went up on that boy's wall. And he, every single day, saw this. And this is the risk that stared him in the face. Deadly toll, 17. Tears, anger, flow. Officials say 19-year-old suspect admitted fatally shooting 17 at the Broward High School. These are the headlines that were on his son's wall for a month. There are pictures of crying students, a prayer vigil, and children streaming out of their school with their hands above their heads. And this headline: Florida shooting suspect displayed flashes of rage and other warning signs. The same thing he was seeing in his own son at that very same time. This was the risk he was ignoring, that there would be a mass shooting of children at a school. And he gave his son the exact tool he would need to accomplish this. He is the reason 4 people are dead, 7 were injured, and countless others were traumatized. And he is the reason a 16-year-old boy was sentenced 2 days ago to the rest of his life in prison. I don't know why the shark is the way the shark is, but everyone understands the risk. From the moment of the horrific attack to throughout the trial, the defendant has shown no remorse for his actions. On the day of the shooting, his daughter texts him at 11:01 a.m. There are 3 people dead at the high school. After that moment, he does not call or text his son because he knows. Instead, he tells his boss he has to leave work because his son broke his arm. And then on the way, he stops at a convenience store to get a drink. And then he just goes home. The next day, he tells his 13-year-old daughter to lie to the authorities. And he comes into court, he takes that stand, and he lies too. Others became heroes that day. Christian Angulo, after being shot in the chest, managed to close the door to just stop the shooter from coming back in. Ronaldo Vega, after being wounded himself, threw desks and chairs to barricade the doors and protect his classmates. Coach Aspinwall and Coach Phoenix, as well as Ms. Irimie, all moved towards the gunshots to try and help and intervene. A young man named Landon Adams, when Taylor Jones was struck in the leg in that room, Landon crawled over to her and held her hand, comforting her until help could arrive. Every child in that classroom was a hero when they came together to comfort and protect each other. And Mason Schermerhorn never got the chance to do that. He was robbed of the opportunity to be the friend everyone knew him to be. But the defendant did nothing. Nothing to stop this, the greatest of risks. The mass murder of children is the maximum of risks and for that he deserves the maximum of punishment. And do not forget that the Crumleys were sentenced to the max that was allowed by Michigan law. For murder, count 1, murder in the second degree of Christian Angulo, the state would ask the defendant be sentenced to 30 years to serve in confinement. In count 3, murder in the second degree for Mason Schermerhorn, the state would ask for 30 years to be served in confinement consecutive to count 1. In count 5, involuntary manslaughter for the death of Ricky Aspinwall, the state would ask for 10 years to serve in confinement consecutive to counts 1 and 3. For count 7, involuntary manslaughter for the death of Cristina Irimie, the state would ask for 10 years to serve in confinement consecutive to counts 1, 3, and 5. For counts 9 through 26, cruelty to children in the second degree, the state would ask for 10 years to serve concurrent to each other and the previous counts. Counts 27 and 29, reckless conduct, the state would ask for 12 months to serve concurrent for each other and the previous counts, for a total of 80 years to serve in confinement. State under court, State versus Bryant, Your Honor, 363 Georgia Appeals 349-202, and Harris versus the State 272 Georgia Appeals 366. Both say that the same incident with separate victims does not merge. And Gaither versus the State 312 Georgia Appeals 53 says that although the convictions arose from the same acts, they did not merge as a matter of fact or law because each count was based upon harm to a different victim. So that is why the state would ask for a sentence of 80 years to serve in confinement.
All right, thank you. We're going to go ahead and take a recess. I need to review what the defense has presented here. Be in recess till 1 o'clock.